All right, so you own property with someone else, but you can't agree on what to do with it.
Yeah, you're in a bit of a predicament.
It can get messy, especially with inherited properties.
Yeah, it definitely can.
Like, what if you inherit a beach house with your siblings, but can't agree on whether to sell it rented or just keep it for family vacations?
That sounds like a recipe for disaster.
Luckily, today we're doing a deep dive into partition actions in California.
That's right.
We've got legal guides, case studies, even advice from attorneys at the Martinez Law Center in Santa Ana.
They specialize in these types of cases.
Exactly. So we're going to break it all down for you.
Should be pretty interesting.
So let's start with the basics. What exactly is a partition action?
Well, in simple terms, a partition action is a legal process that allows co-owners of a property to divide or sell the property if they can't agree on what to do with it.
Okay, so it's a way to force a resolution when everyone's at a standstill.
Yeah, you could say that.
And this is especially relevant in California, right?
Absolutely. California law actually grants a near absolute right to partition.
Meaning?
Meaning if co-owners can't agree, the courts can step in and make a decision for them.
Wow. So it's not just a suggestion. It's like the law's way of saying, figure it out or we'll do it for you.
Pretty much. Yeah, it's designed to prevent these disputes from dragging on forever.
I can see how that would be necessary. Imagine siblings arguing over that beachfront property for years and years.
Exactly. It can get really messy, and that's a classic scenario where a partition action might come into play.
Speaking of scenarios, we've got some really interesting real-world cases in our sources.
Oh, yeah, fill me in.
We've got that beachfront property dispute between siblings in Orange County.
Right? Sounds familiar.
A case involving a family farm in San Diego.
Multi-generational, I bet.
You bet. And even an investment property disagreement in Riverside.
So a little bit of everything.
Yeah, it seems like anything can trigger these legal battles.
You're telling me.
But these cases also highlight the different types of partition actions, right?
Oh, yeah, for sure.
So what are the main types?
Well, the most common type is partition by sale.
Partition by sale.
Yeah, where the property is sold and the proceeds are divided among the co-owners.
Okay, so that's like the cleanest break. Everyone gets their share and moves on.
Right. In most cases, that's the simplest solution.
But sometimes selling isn't the best option.
Yeah, exactly.
What happens then?
Well, that's where partition in kind comes in.
Partition in kind.
Yep. This involves physically dividing the property among the co-owners.
So you actually split up the land or the house or whatever it is.
That's the idea.
I can see how that would be tricky.
It can be. Yeah, especially if the property isn't easily divisible.
Like if you have a single family home, you can't really chop it in half.
You can't, yeah. So partition in kind is more common with larger pieces of land, like that family farm in San Diego County.
Right. That case is a perfect example. They were able to divide the land and keep it within the family.
Exactly. And that's often a desirable outcome in these cases.
But there's one more type, isn't there?
You got it. Partition by appraisal.
Partition by appraisal.
Yep. In this scenario, one co-owner buys out the other co-owners based on the property's fair market value.
So you get an appraisal, and then someone pays the others their share and becomes the sole owner.
That's how it works.
Interesting. And we see this happening in that Riverside investment property case, right?
Yep, exactly. One of the investors decided to buy out the others and keep the property.
So we've got these three main types: partition by sale, partition in kind, and partition by appraisal.
Those are the big ones, yeah.
And each one has its pros and cons depending on the situation.
For sure.
So let's say you find yourself in this predicament. You're a co-owner and things just aren't working out. What's the first step?
The first step is to talk to an attorney.
Okay, so get some legal advice.
Absolutely. An attorney who specializes in partition actions can help you understand your options, the legal process, and the potential outcomes.
And I imagine they can also help you navigate the emotional side of these disputes, which can be pretty intense.
Oh, yeah, absolutely. These cases often involve families or longtime business partners, so there's a lot more at stake than just the property itself.
Right. You've got relationships, history, all that stuff tangled up in the legal mess.
Exactly. And a good attorney can help you navigate those complexities and hopefully find a solution that minimizes the damage.
So finding the right attorney is crucial.
Couldn't agree more.
And for those of you in Southern California, the Martinez Law Center is a great place to start.
They have a lot of experience in these cases.
Absolutely. They've handled everything from beachfront property disputes to family farm divisions.
They're the real deal.
Now it's not just about filing paperwork and waiting for a judge's decision, right?
Oh, no, there's a lot more to it than that.
What else should people be aware of?
Well, for one thing, accounting plays a big role in partition actions.
Accounting?
Yeah, it's all about figuring out who contributed what to the property.
So who paid for what? Who put in the most money? Who's responsible for any debts?
Exactly. All of that gets factored in when determining how the property is divided or how the proceeds are split.
It makes sense you want to make sure everyone gets their fair share.
Right. And accounting helps ensure that happens.
Now, things have gotten even more interesting lately with recent changes to California law directly affecting partition actions.
Oh, yeah, there have been some significant updates.
And these are particularly relevant for anyone who owns property in California, right?
Absolutely. These changes can have a big impact on the outcome of these cases.
So let's talk about some of these changes. What are some of the highlights?
Well, one major change is AB 976, which focuses on fair market value during buyouts.
Fair market value.
Yeah, it's all about making sure that when one co-owner buys out the others, they're paying a fair price.
Okay, so it's about preventing anyone from getting lowballed.
Pretty much, yeah. It aims to create a more equitable outcome for everyone involved.
Makes sense. What else is new?
Another important update is SB 1146, which provides extra protection for elderly or dependent co-owners.
Okay, so this is about protecting those who might be more vulnerable in these situations.
Exactly. It aims to prevent them from being taken advantage of or pressured into making decisions that aren't in their best interests.
It's good to know the law is looking out for those who need it most.
Definitely. And then there's AB 2175, which streamlines the process for certain types of properties.
Streamlines the process.
Yeah, it aims to make things a bit more efficient for everyone involved, especially when dealing with properties that meet certain criteria.
So it's all about cutting down on the red tape and making the process a little less painful.
That's the idea.
I like it. Efficiency is always a good thing.
For sure.
So we've got these new laws that aim to make the process fairer, more efficient, and more protective of those who might be vulnerable.
Exactly. It's all about improving the system and making sure everyone gets a fair shake.
Sounds like a step in the right direction.
Definitely.
Now, the Martinez Law Center shared some great advice for anyone even thinking about going down this road.
Oh, yeah, they're a wealth of knowledge.
What are some of their top tips?
Well, first and foremost, document everything.
Document everything.
Yep. Keep track of all expenses, communication agreements, anything and everything related to the property.
Okay, so create a paper trail.
Exactly. That documentation can be crucial if a dispute arises. It can help prove your contributions, your expenses, and any agreements you've made with the other co-owners.
Makes sense. What else do they recommend?
They also advise exploring alternatives to court action, like mediation.
Mediation.
Yeah, it's a way to try to resolve the dispute outside of the courtroom with the help of a neutral third party.
So it's about finding a compromise that works for everyone.
Exactly. And sometimes mediation can be a much faster and less expensive option than going to court.
It's worth considering, for sure, especially if you want to try to preserve relationships.
Absolutely. And the Martinez Law Center also stresses the importance of understanding your rights as a co-owner.
Know your rights.
Yep. You need to know what you're entitled to, what you can and cannot do, and what options you have available to you.
Right, because you don't want to go into this blindly.
Definitely. And finally, they emphasize the importance of being prepared for the emotional side of these disputes.
The emotional side.
Yeah, as we talked about before, these cases can be very emotionally charged, and it's important to be prepared for that.
So you're saying don't underestimate the stress, the anxiety, the potential for conflict?
Absolutely. It's real, and it's important to be prepared to deal with it.
So we've got some great advice from the experts.
Yeah.
Document everything, explore alternatives, understand your rights, and be prepared for the emotional roller coaster.
Those are some solid takeaways for sure.
And they also had some words of caution.
Right? Oh, yeah, they definitely did.
They said ignoring communications from your co-owners is a big no-no.
It's a recipe for disaster.
Why is that?
Well, ignoring communication just escalates the conflict and makes finding common ground even harder.
It's like shutting down any chance of resolving things peacefully.
Exactly. And it can also be seen as bad faith by the court, which can hurt your case in the long run.
So keep those lines of communication open.
Absolutely, even if it's difficult.
And they also warned against underestimating the costs involved.
Oh, yeah, the cost can add up quickly.
Like what kind of costs are we talking about?
Well, legal fees, of course, but also property valuations, expert witness fees, court costs, all sorts of things.
It's not just a small filing fee and you're done.
Nope, it can get expensive.
So going into this with your eyes wide open is crucial.
Couldn't agree more. You need to understand the potential financial burden before you make any decisions.
Makes sense. And I think what's really interesting is how the Martinez Law Center emphasizes the emotional side of these disputes.
It's a big part of it, for sure.
It's not just a business transaction. It's families, relationships, shared histories, all tangled up in this legal mess.
Absolutely. And those personal dynamics can make things even more complicated and challenging.
They definitely can. Speaking of real-life examples, let's go back to that Orange County beachfront property dispute.
The one with the siblings.
That's the one that ended in a partition by sale.
So they sold the property and split the proceeds.
Exactly. But it wasn't just a simple division. They had to take into account one sibling's contributions to the property's upkeep.
Oh, interesting. So it wasn't just a straight split based on ownership percentages.
Right. They had to adjust the division to reflect the fact that one sibling had invested more in maintaining the property.
It's all about fairness in the end.
And remember that Riverside investment property?
The one where one investor bought out the others.
That's the one that was a classic partition by appraisal scenario.
Yep. A court-appointed appraiser determined the fair market value, and then one investor paid the others their share.
Exactly. And that avoided a potentially messy sale on the open market.
It's a good option when it's feasible.
And then there's the San Diego County family farm.
Where they actually divided the land.
That's right. They went with partition in kind.
So different branches of the family each got a portion of the land.
Exactly. They were able to keep the farm within the family, but just divide it up.
That's a great outcome, especially for a multi-generational family farm.
It preserves the legacy.
It does, and it allows different branches of the family to continue farming if they choose to.
And we can't forget about the commercial building in Los Angeles.
Oh yeah, what happened there?
The former business partners were able to negotiate a settlement during the partition action.
So they avoided a forced sale.
They did.
Yeah.
And that allowed them to salvage, at least to some degree, their business relationship.
It's always better to find a solution that works for everyone, if possible.
I agree. These cases really highlight how different the outcomes of partition actions can be.
It's definitely not one size fits all.
But there's one thing that really stands out to me: the importance of a well-crafted partition agreement.
Yeah, that can make a huge difference.
It's like a prenup for co-ownership, wouldn't you say?
Exactly. It's a proactive way to manage potential conflicts and avoid ending up in court.
So if you're thinking about co-owning property with someone, this is something you should definitely consider.
Couldn't agree more. It's all about planning for the future and avoiding potential headaches down the road.
So we've covered a lot of ground here. Just to recap for our listeners. Partition actions offer a legal solution when co-owners can't agree on what to do with the property.
Right.
Recent California laws aim to make the process fairer and more efficient.
And more protective.
And professional legal guidance is crucial.
Absolutely don't try to navigate this on your own.
But there's one last thing I want to leave you with.
What's that?
Even with a legally fair outcome, there can be non-financial consequences,
Oh yeah, for sure.
like strained relationships or the loss of a family legacy.
Those are big ones.
So it's not just about the money, it's about the human side of these disputes too.
Couldn't agree more.
It's something to think about as we delve deeper into this topic in our next segment.
Definitely looking forward to it.
Me too. Stay tuned.
So we've talked about the different types of partition actions and some real-world examples, but let's dive into some of the legal specifics.
Yeah, let's get into the nitty-gritty.
All right, so the California Code of Civil Procedure, that's where all the rules of the game are laid out.
Okay, the rule book.
Exactly. It outlines the steps involved in filing a complaint, serving notice, all that legal stuff.
Sounds pretty dry.
It can be, but it's the foundation of the legal process. It's what makes sure everything is done by the book.
So it protects everyone's rights.
Precisely. And it gives the courts the power to actually enforce these decisions about dividing or selling the property.
So it's not just a suggestion, it's the law.
Exactly. The California Code of Civil Procedure makes it all official.
Okay, so we've got this legal framework, but what about the practical steps involved? What actually happens when you decide to pursue a partition action?
Well, it can seem a bit daunting, but it's actually a pretty straightforward process.
Okay, break it down for us.
First things first, you need to consult with an attorney, someone who specializes in partition actions.
Okay, so find an expert.
Exactly. They'll assess your specific situation, explain your options, and guide you through the whole process.
Sounds like a good first step. What's next?
Next comes the official part. You file a complaint with the court in the county where the property is located.
Okay, so you're officially kicking off the legal process.
You got it. And then it's all about making sure all the co-owners are officially informed.
So everyone knows what's going on.
Right. That's called serving notice, and it's a crucial part of the process.
Makes sense. So you file a complaint, serve notice, and then what?
Then it's all about case management, court hearings, and ultimately reaching a resolution.
So there's a whole legal dance that takes place?
Yeah, there is, and it can take some time, but having that attorney by your side can make a huge difference.
So they're like your legal choreographer guiding you through all the steps.
Exactly. They make sure you don't trip up along the way.
And speaking of tripping up, The Martinez Law Center highlighted some common pitfalls to avoid.
Oh yeah, they've seen it all.
What are some things to watch out for?
Well, one big one is failing to consider all your options. Sometimes people get so focused on one solution that they overlook other possibilities that might be better for everyone involved.
Okay, so don't be too quick to jump to conclusions.
Right. Explore all your options. Talk to your attorney. See what makes the most sense for your specific situation.
Call now 714-442-9741. Thank you.